morning. It's the media's turn.
It's for later.
Okay.
Sorry.
Okay, we're here for the media's motion. Supplemental motion concerning access to evidence admitted at trial. And Mr. Cruz doesn't need to be present for this, correct?
No, it is not. It's not a critical stage of the proceedings.
I agree.
Awaiting his appearance.
Okay, and the state's present. Ms.
Yes, Your
McElroy,
Honor.
you want to come on up and let me know what it is that you're asking for? Please.
Thank you, Your Honor. May I move the podium a little bit?
Sure.
Thank you. Good morning, Your Honor. Dana McElroy, here representing the Associated Press, Gannett Company, Inc., the Miami Herald, the New York Times, the Sun Sentinel, Tegna, and Times Publishing Company. In our motion, we seek access to evidence which is admitted into the court record and would be shown to the jury. We have broken down our request to two separate categories which are important for the motion. One is evidence which is admitted, which is not sensitive or graphic. And I'll call that, for lack of a better term, the regular evidence. And then secondly, there's sensitive or graphic evidence, which would be crime scene photos, videos, autopsy photos, things like that. And in that situation, we're seeking, as to the sensitive evidence, only to view and not copy or in any way duplicate what is admitted into evidence and considered by the jury. So just as I go through, I'll refer to the regular evidence in one way and the sensitive evidence in another. As a preliminary matter, and as recognized in numerous U.S. Supreme Court cases and Florida cases, jury trials are presumptively open under the First Amendment. The reasons for this are undisputed. The reasons for this is an undisputed constitutional right under the First Amendment. And it's articulated on page 3 of our motion in the Richmond newspapers case, where the court, U.S. Supreme Court, explained, public scrutiny of a criminal trial enhances the quality and safeguards the integrity of the fact-finding process, with benefits to both the defendant and to the society as a whole. Moreover, public access to the criminal trial fosters an appearance of fairness, thereby heightening public respect for the judicial process. And in the broadest terms, public access to criminal trials permits the public to participate in and serve as a check upon the judicial process, an essential component in our structure of self-government. In sum, the institutional value of the open criminal trials recognized in both logic and experience. And I'll just pause and also advise the court that I have, in the run-up to this today, and I appreciate the court's time, conferred with both the state and the defense in this matter, and neither opposes our motion.
I don't understand what you're asking for.
Okay.
And I don't understand the difference between the two, and I also don't understand why it is that what I've given you, the access that I've given you, is not enough.
Okay, if I may, I'll continue just a little, and then I can answer your question.
Okay, I've read your motion. I really don't need to expand on the case law. I understand it. You can go ahead. You can read the case law to me.
That's okay. I'll do whatever the court would like. I would just like to make sure I make a record, but I can try to answer the question. If I don't, maybe I'll ask one of the parties to assist me.
Okay.
Because what I understand is that there will be a subset of evidence that is proffered by the state. We'll start with the state. That is what we would consider regular, non-sensitive evidence. In other words, evidence that will be accessible to the public immediately or contemporaneously, maybe on these monitors, or maybe otherwise. And I believe we're making a distinction between that kind of evidence and the sensitive or graphic type evidence, which we're not asking for access to contemporaneously at all. What we're asking there, and those are crime scene photos, autopsy photos, other things that are invoke or...
Exactly. Okay, let me stop you, because I'm not understanding. With regard to regular evidence, how are you suggesting that the media be able to view it? Tell me the exact process you're proposing.
Either how you said yesterday, where we come look at it, or it'll be displayed on the monitors. That's not a difficult question.
Okay. And then how are you proposing to view the sensitive evidence?
What we are proposing is that we be allowed to, as I understand the process, it's going to be shown to the jury if admitted, and I'm only talking about admitted evidence.
I understand.
Okay. It will be shown to the jury on these monitors, but will not be shown to the public in any way or broadcast. In other words, it'll be cut.
How do you propose that the media views it?
Okay, that we'd be able to come and look at it at some point that doesn't take up the court's time and resources in a secure manner.
Okay, I don't understand I still don't, that's exactly what I did yesterday. So what is it that you are complaining about?
Well, what I understood from yesterday is, first of all, if you're just saying we can come up and look at the clerk, we're talking about possibly hundreds of photos. We're talking about videos. We're talking about, so it's a big world of evidence that is not easily that we can just walk up to the clerk. That's not in a secure way. In other words,
my plan is to have everyone leave the courtroom except for the media representatives. Then I'm going to be here, the sheriff's office is going to be here, and the clerk's going to be here in open court, which is the most secure way that I can give you. Okay. And then my procedure was that the media can have several representatives, depending on, you all can decide among yourselves who's going to be the representatives for that day. And then I'm going to give you what I said was a reasonable amount of time to view the evidence. Now, if we finish at 7 o'clock at night, the clerk and I are not in this sheriff's office. We're not going to stay here till 9 o'clock at night to watch you view it, and I don't think the law requires me to do so. I'm going to give you a reasonable amount of time at the end of each day to view the evidence.
So that would include the sensitive evidence?
Yes, everything.
Okay, I just want to make sure that that is acceptable to the state and to the defense, because the state had concerns that and Your Honor can, of course, order this, and we would have to comply. We would be willing to comply, obviously, but that there not be the ability of maybe an outlier to take a picture or somehow duplicate.
That's the reason, state. That's the reason that I want to do it in the courtroom with myself sitting here. Okay. I don't want any lawyers, no one except for myself, the sheriff's office, and the clerk. We will be here, that way I'm here observing what's going on, the clerk's here observing what's going on, we give them a reasonable amount of time. At the conclusion of each day, it will be secure. The sheriff's office already knows they're going to be part of this, and if the media anybody tries to do anything like take an illegal picture in front of the judge and the sheriff's office, then shame on them.
Your Honor, and the state appreciates the concern that the court is obviously, the thought and concern the court has put into this. And I would suggest that in the old days, when there used to be a bench and a gate before the parties could approach,
sure,
that maybe the media leave their bags and their cell phones and their personal effects behind before they approach to look at the photographs, because as Ms. McElroy and the state discussed, I'm sure she discussed it with the defense as well, and I know we brought it up to the court, that we don't want anyone to surreptitiously take photographs of this evidence with their watch, with glasses, with a cell phone in a pocket, with any sort of device. And so we would ask that, I know you're going to be watching them, but I just want to make sure that since no representatives from the state are going to be in here, and assumably none from the defense, that those safeguards are put in place.
Look, if you all want to have a representative from the state and the defense present, that's fine with me, but I thought it would be easier for you all to not have to stay every night of the trial and do that.
We have investigators who can do that, Your Honor.
If both sides want to have an investigator here, that's also fine. I'm also going to have whoever is the, I don't know if you all are going to elect them, appoint them, the media representatives for the day. We're going to have a sign-in sheet, and they're going to write their name and their agency, and we're going to make sure they have a press pass, which they shouldn't be in here if they don't. That way, if anything like that goes on, there's a recourse.
That's fine, and the procedure that Ms. McElroy has laid out is agreeable to the state, and it is exactly what this court has laid out as well, Your Honor. I think there was just a misunderstanding as to maybe more was granted than was necessary, because with regard to the regular evidence,
Right.
It's going to be readily available for everyone to view via the monitors that are going to be available in the courtroom, and we're really only discussing sensitive evidence for the procedure that you envision.
Okay?
Thank you, Your Honor. That takes care of our motion and our concerns, and I appreciate that.
Okay. So if the state and the defense want someone to be here for this process, I'm just going to ask that you let me know who the person is, and we're going to have both sides here every day. You see what I'm saying? If the defense side isn't available one day or the state side's not available one day, I don't want one or the other. I want both or neither.
Okay.
Please.
We'll probably know that as the day goes on. I don't know that we'll know that in advance.
That's fine.
But we'll get with the defense and work that out, Your Honor.
Okay.
Your Honor, are you going to have like a table in front for the evidence?
We can, why don't you have, why don't you all speak to Hortense about exactly what you want?
Okay.
She's been through this process.
And we've worked with Hortense
Right.
before, so she knows what we...
I'm sure she knows what you need. She's been in a big trial. That's why they graciously assigned her to me for this trial. And let her know what you need, and then we'll get it done.
Okay, perfect. Thanks, Hortense.
Thank you.
And the same for you, Ms. McNeil.
Thank you.
Sure. Okay, is there anything else?
Now, Your Honor, would you like me to submit an order, or?
We'll do a written order.
Okay.
I'll do a written order, okay?
Thank you.
All right, thank you. So, was it 1 or 1:30? I can't remember.
1:30.
1:30. All right, we'll see you at 1:30. Thank you.
Judge, just so you know, that's the redaction. It's amended. You were correct
So
yesterday.
should I throw away the one from yesterday?
Yes.
Thank you.
Thank you for letting
Should I
me know.
throw away the transcript from yesterday?
Yes, I gave you a color copy.
Okay.
And
It's thinner because it's double-sided.
Yes.
Okay.
The state has the same. And then you wanted the video, and that's what that was.
Thank you.
I assume
Yes.
if I have a laptop set up, I'll assume you'll have to have a laptop set up.
That we put dogs in that.
A personal laptop, not their own laptop, because then they can move files onto the computer.
So at the end of the day, I
So
think
like
it's for the.
record out of it or something.
I'll
Or,
figure out.
or the judge would turn her screen around. Control it.
That's what I need to know, because I don't want this to happen last minute where they.
Right. Yeah, I'll find it. Yes. There was nothing, it was all already settled.
Yeah.
Or maybe even easier. Or maybe even easier so the
I don't like it.
You said the seal?
Yeah. Not just for the. Yeah, that's one of those. Yeah, we're good. This is.
You just said,
Yep, yep.
there's nothing behind you, right? No.
Nope,
No?
nothing on the board.
Can you see the other one?
But the answer is, do you need to do it? Yeah, it's not. Yeah. I don't need a first aid kit.
Oh, yeah. Cause that's their thing.
She would go, I was like, oh, you're great. She wouldn't go. But like, there's like 5 or 7 before us that wouldn't go. So I think that might have been it. But meanwhile, my older one, my daughter, she's so so she walked up. Mother like, she can do a lot of wrong. I'm like, that's right. The rest of them, literally, they keep on staring. I got off because I thought, if I leave her, she'll be scared. Started leaving her, but I both sides are present, and we are here on the defense motion. Help me out. I know what you're moving to exclude the videos, I just don't remember the number or what exactly you termed it.
Your Honor, if you will allow me, before Mr. Wheeler makes an argument, I would just like to put something on the record.
Sure.
Okay. And that is, the state is objecting to a hearing on the exclusion or any sort of hearing on the videos or the photographs today or on Monday. And the reason, Your Honor, is that on, I guess it was Thursday or Friday, when we were in court, the defense said they wanted to have a hearing on this right away. They wanted to have a hearing right away because Mr. Secor had worked all weekend on the photographs and they wanted it done right away. And that's not a legal reason to have a hearing on this now. And in fact, Your Honor, the state believes that having a hearing on these issues now, prior to trial, would lead this court into reversible error. There are a lot of photographs in this case because there are 17 murder victims.
Okay.
All right? So, as you know, you've been a trial lawyer and you've been a judge for many years. Photograph evidence, the determination of its admissibility is based on relevance.
Right.
Okay? You cannot determine relevance in a vacuum. So, to have a hearing today on the admissibility on this evidence, whether they're videos today or photographs on Monday, cannot be determined in a vacuum. It has to be determined after listening to evidence that's presented at trial and testimony that's presented at trial. For example, the medical examiner. As you know, the medical examiner will testify that a photograph will aid the medical examiner in describing the injuries and the cause of death. And this court, or any court, would make a ruling on the admissibility and relevance of that photograph based upon what the medical examiner said. There is nothing for this court to rule on right now because, quite frankly, it hasn't been presented with any evidence or any trial testimony. And to make a ruling in a vacuum could lead this court into error. And it will be an issue on appeal. Furthermore, if this court were to indulge the defense and make a ruling, it wouldn't be the only ruling that this court would make on the evidence. Because as evidence came in during the trial, the defense would ask this court to revisit its prior ruling. And so, in fact, this court would be making multiple rulings on the same piece of evidence that the defense is asking the court to rule on today and Monday. So it's the state's position, Your Honor, that you cannot make a ruling on the admissibility of the video clips or the photographs without placing them in their proper context. And the context is the testimony of witnesses produced by the state at trial. This is the state's evidence. And frankly, there's no testimony here. The defense is asking you to make a ruling. We believe it's potentially leading you into error to make rulings on the admissibility of evidence without putting it into any context. Because what are you going to base your ruling on? An ask? It's improper. So it is premature, Your Honor, to make a ruling now under these circumstances. And they will ask again, if you were to make a ruling today, they will ask again for you to revisit it. We had a meeting with the defense last week where we had given them a list of all the photographs. We didn't give them the photographs, they already had them, but we gave them a list of the photographs that we had that we were contemplating using in trial. And we told them that if they wanted to discuss any of the photographs regarding their admissibility, if they had any problems with them, we would talk about it. And rather than do that, they decided that they wanted to move and object basically wholesale to all of the photographs and the videos. I filed a motion this morning, moving to exclude them. And this is an issue that will continue to come up. To address this issue now is an anomaly. In all the years, and I only speak for myself, Your Honor, I can't speak for the other lawyers in this room or the other judges in this courthouse. And I've never seen a case where the judge made a ruling prior to trial out of context without the benefit of a medical examiner or without the benefit of a witness to explain why a piece of evidence is relevant, whether it's a photograph or anything else, and for a court to rule on its admissibility, that the court would rule prior to trial. On a motion to suppress, you would hear the testimony of an arresting officer or somebody who took the statement. You wouldn't just look at the statement and say it's in or it's out. You would have to hear evidence. And it's the same thing with the photographs, Your Honor. And just to put it in context, if you allow me to finish.
Sure.
There are a lot of photographs because there are a lot of victims. We have crime scene photographs and we have medical examiner photographs. But I just want to put, to put it in context, the medical examiner took photographs of one of the victims, and there were 217 photographs taken by the medical examiner, and we're only using 11 of that 217.
For one victim.
For one victim. And for another victim, there were 89 photographs taken by the medical examiner, and we're only using 6. So we are not trying to be repetitive with photographs. These victims were shot with an AR-15 by this defendant. They have multiple wounds, and we have to depict, for purposes of not just aggravation, but the nature of the crime, the injuries, and the cause of death suffered by these victims because of this defendant. And we're going to do that, Your Honor. And these pictures are relevant, and they deserve the attention to detail that this case is getting from all the parties in this courtroom. We would ask that you defer ruling on the defense's motion until the proper time, and the proper time is after evidence is adduced showing why the evidence is admissible.
Okay, I would agree with you as far as the relevance factor goes, especially with the medical examiner testimony, because I would agree, I'm sure the defense would agree that in order to meet the relevance threshold, the state would have to have a witness to testify why exactly the certain photo is relevant. Without having the benefit of the witness testifying, I understand your argument on relevance, but if there are other arguments to be made, is there a reason why I couldn't hear them today? I have reviewed the videos. I won't rule today. I'll rule when the state goes to admit the particular item, or at the time that the state wants to admit the particular item. At that time, I can determine relevance and consider any additional arguments that perhaps the defense wants to make today as a reason why they should be excluded. Or do you think that all needs to be done at the same time? I'm just wondering about saving time since we're here. But I definitely understand your argument to the extent that of relevance.
Your Honor, the only arguments that the defense has raised is relevance versus probative value, prejudice. And I don't think that this court can make that determination without looking at all the evidence. It would be a duplication of this court's efforts and time, and the party's efforts and time to make argument now, to have this court use its time. We're all in a time crunch, and then to have it done down the road at another time. The only argument is relevancy. Even on a penalty phase, on capital cases where there's a resentencing, it's the same standard, Your Honor. And I would cite for the record the Kearse case, and that's 770 Southern 2nd 1119. And I'll read into the record: the test for the admission of evidence is relevancy as to the nature of the crime and not just as to whether the evidence was admissible to prove any aggravating or mitigating circumstances. Court has discretion, Your Honor, as to the admissibility of these photographs. The test is relevancy. This is a proceeding before a jury that has not heard anything. In essence, it's a trial, although the defendant has pleaded guilty. The jury doesn't have to hear this evidence in a vacuum. It needs to have the full benefit of what happened, the nature of the crime, not just the aggravating and the mitigating circumstances. And it's for that reason, Your Honor, that this court, who is also doesn't know, didn't sit at a trial, and is coming in here now at a penalty phase, you don't know the nature of the crime, except for what's happened in court here.
Sure.
And it really is, it's taken, you have to be put in the context of this case as well, Your Honor. You're at a disadvantage to make rulings on the admissibility of photographic evidence, how it relates to the nature of the crime and the aggravating circumstances without hearing the evidence from the state's witnesses.
May I be heard, Your
Sure.
Honor? Judge, I can put on the record 2 cases, and I don't have the case numbers, but State of Florida versus Fidel Lopez and State of Florida versus Elton Walters, those were both death penalty cases. One was in front of Judge Levinson and one was in front of Judge Holmes. In both of those cases, where it was very gruesome crime and there were a lot of photographs, in both of those cases, with the same prosecutors, we had pretrial hearings on the admissibility of photographs and videos. So I don't understand the argument of this being in a vacuum. This is a procedure that I have been following in most of the cases that I have tried, but I'm just referring to those 2 because those are 2 death penalty cases. I also don't understand the state's position that it would be reversible for the court to make a pretrial ruling. You can make them all without prejudice. Of course, to protect the record, we would have to renew our objection like we did during jury selection if we believed, if we disagreed with the court's ruling. As to the medical examiner's testimony, during the course of some of the depositions of the medical examiners, and there were several because there was multiple victims, some of those medical examiners indicated that they didn't need the photographs in order to describe the cause and manner of death. I'm not conceding anything, but I understand that the cause and the manner of death needs and requires some explanation. The cause of the death is that Nikolas Cruz murdered them. It's a homicide. So the cause of death, when he pled, is not in dispute. And we appreciate the fact that the state has narrowed down, and one example I believe Ms. McCann gave, 89 photographs of one victim, and they narrowed it down to 6. We appreciate their efforts in doing that. However, the defense can still have objections to those 6 photographs, and I can tell you that the majority of those objections will be maybe this photograph, which covers the same injuries, is less gruesome than this photograph, or maybe they're cumulative.
But I don't mean to interrupt, but I just want to ask you this question while it's on my mind. Given the example of, since I haven't heard the testimony yet, using your example, how would I know whether or not the medical examiner is going to say, well, this shows A, and this shows B, even though they may seem to the person that doesn't know anything about this autopsy to be depicting the same thing, they actually show different things without having the benefit of the testimony, because I don't, like the state said, I don't know this case like you, not even close.
No, and I appreciate the court's acknowledgement that you need that information, and it is relevant. However, some of these photographs are of the exact same injuries, okay? And we also have the medical examiner's reports that would be able to differentiate between the pictures. Judge, the need to have this hearing set this week was because we were supposed to have an Albert hearing.
Sure.
And when that was canceled, you told the defense and the state, get busy and get this stuff done. And we immediately met with the state, and when we met with the state, they did give us the videos that you reviewed, but they gave us numbers of photographs. They didn't identify the photographs. So we worked knowing that we had this week to do all the hearings, to get that information done, to review that, to make our objections. The motion that was filed yesterday or this morning is new in the sense that it just lays out some specific arguments. However, we initially filed this motion back on December 3rd of 2021, and that was D-190. The grounds were there. We've been asking for this hearing for a really long time, and mostly it's for efficiency purposes, Judge, so that we don't have to stop before each
I
witness.
appreciate that, for sure.
And in reference to ruling in a vacuum, the state has repeatedly asked Your Honor to rule on motions in a vacuum. An example of that would be what they believe constitutes third-party negligence. You didn't get the whole picture there in order to make a ruling on that. So I think it's, their position is inconsistent with the things in which they have asked this court to do. We met with the state. We've been in court with the state. We correspond, or I did. I texted with Mr. Marcus, and we are here this morning. And all of a sudden now they don't want to have this hearing, or we've all been working towards it. I don't know when we'll be able to do it, but it's not because Mr. C4 worked all weekend. It's because we were under court order to get this stuff done.
Okay.
I understand that this is heart-wrenching and it's difficult, but it's something that needs to be done. And we're prepared to move forward, Your Honor.
Your Honor,
Sure.
I can represent that the prosecutors at this table were not involved in Elton Waters or the Fidel Lopez case, so we did not participate in that procedure. And I can also say that the procedure suggested by the defense, instead of being the most efficient way to handle this, is the least efficient way to handle it, because we can address this during the trial like every other case and talk about if the photograph is admissible and do it in its proper flow and order and context. And that way, this court is fully advised as to the facts and circumstances of this case and whether or not the court will rule in favor or against the state as to the admissibility of the photographs. This is not an efficient way to do things. In fact, it's an inefficient way to do things. And just to do this to fill time is not a reason to have a hearing, Your Honor. It's not a reason to make a ruling that's potentially reversible error, no matter what the defense says, because the lawyers who are going to be litigating this, if the defendant receives death, if he receives death, this case is going to go on for many years. And it's not going to be the public defender's office who are going to be representing him and making claims. It's going to be other lawyers who will go through this record and pick out all kinds of issues and will potentially say that his lawyers were ineffective for raising this claim and doing it now. So I would urge this court to refrain from having a hearing now and to do this hearing regarding the admissibility of evidence in the proper course of the trial as the evidence becomes relevant and the state seeks to admit it. That's all, Your Honor.
Okay, so,
Judge, may I just add
Sure.
really quick? The frustration is the state could have filed a motion back in December of 2021 and said, this is our objection. We have been traveling under the impression that this motion would be heard. We are all working at full capacity, and in order to comply with the court's order, we got this motion ready. And it's not until we walk into this courtroom that this objection is made, when obviously they've had this position for quite some time. It hasn't been heard. So that it's very frustrating for the defense to have to be in this position. And I understand that relevancy is the test, and you may find that most of these photographs are relevant. But there's other analysis that the court has to do, and one of those is that they're cumulative. And that is something that you can do. You may find that, and I don't want to speak about any particular photo, so I'm just going to say, photo A, B, and C depict the exact same thing. I believe that they're relevant. But then you may say, but we don't need 3 photographs. So we can deal with the cumulative nature of the photographs. And then when trial comes in, you can make a determination on relevancy. I'm not trying to just fill court time.
I understand.
I'm trying to take care of matters that need to be taken care of, but also that you wanted us to take care of.
okay,
So I have no other issues. with the
is
court.
there a reason why, I've already reviewed the videos. I do understand the state's position in that when I'm reviewing them, I am reviewing them in a vacuum. And if the names weren't on there, it would be very hard for me to sort of it's hard to understand what's going on because I haven't heard anything that would explain what what's going on, if that makes sense. In other words, I can visualize it, but I haven't heard any testimony to describe what's happening, so it's hard to know what to focus on or what is important or what is not important, or maybe it's all important. However, because I've viewed the videos, I think that I can make the relevancy determination at the time of trial, but I think if there's other arguments, I can hear them now, and then I can defer ruling until trial when I can make my decision. And you all are not going to make, if you make your argument today, you're not going to make the whole argument again, are you? You're going to preserve your objection, I assume.
Well, if the court wants to move forward just based upon the cumulative nature of some of the videos today, Judge, I would limit my argument to the cumulative nature of the videos.
I mean,
and I would reserve the relevancy argument for that time when they seek to introduce the photographs.
If you're going to allow something in over objections that we make here today, we will just renew and rely on previous arguments unless there's a new ground.
okay, but you agree with, unless there's a stipulation as to relevancy, and unless you all are going to stipulate to certain facts that I can consider as being testified to as facts, I can't make the state's right, I can't make the relevancy determination today, because I don't know.
I think that's fine.
I think maybe sometimes you all forget, and that's through no fault of your own, but there's a lot of times during criminal cases where the judges hear, motions to suppress, and we've heard a lot of motions in this case, but not necessarily fact related. I think I heard from 2 detectives, but they testified really to just bare bones. They didn't get into detail, so I am somewhat at a disadvantage in viewing those things. I didn't realize it until I was watching it, that it was hard to sort of follow along without having the facts presented along with a testimony to aid in my decision. Do you see what I'm saying?
I do, Judge, but I think that at the very baseline, the court can accept this fact that Mr. Cruz has pled 17 counts of first-degree murder and 17 counts of attempted first-degree murder.
17.
That's by 7.
You said 15.
No, 17. And furthermore, Judge, we're in agreement as to the cause and manner of death as well as the identity of the victims, Judge, which would take away the gravity from the testimony of the medical or the necessity of medical examiners.
Okay.
Your Honor, if I could just say something?
Sure.
You said something a few minutes ago that was really, really important. You said with regard to the photographs, you wouldn't know what to focus on without knowing the context of the case. It's the same exact thing with regard to the videos.
Well, I was just going to say that, for example, when I'm watching a video and I see a group running in one direction, even though it says east or west, and then you see them running in the other direction, and then you see them running in another direction, and then you see what appears to be Mr. Cruz walking down, but without hearing from a witness to say, to explain that sequence of events.
And Your Honor, not only do you not know the orientation, the east, the west, the north, the south, what floor they're on, you don't know that. You don't know what stairwell they're on. You don't know what you're looking at without hearing from a witness. You don't know the alcoves. You don't know what victims were focusing on. It's an exercise in futility at this point for you to look at the video because you don't know what you're looking at without an explanation. You're looking at a gruesome video. You're looking at a gruesome video without knowing who is here and who is there and who these people are. It doesn't, like you said, Your Honor, with regard to the photographs, you don't know what to focus on. The same The same analysis applies to the videos. It's no different, Your Honor, and that's why there are so many different videos, because they all emphasize something different, because there are 17 victims. There's not one victim. There are 3 floors in this school. There are different hallways. There are different stairwells. The victims are found in different places. We see them in different positions. You cannot just look at this and make a ruling. You have to know what you're looking at in order to make a ruling, Your Honor.
Okay, I agree with you, but I do think that reviewing the evidence beforehand will be helpful for me, because at the time when I make my ruling, it won't be the first time that I'm viewing it. I think viewing those videos, even though it's hard for me to understand exactly what's going on, it will be helpful for me in the future. And also, if the defense wants to make arguments today and just simply, because we're all here, and simply reserve those arguments during the trial, other than relevancy, I'm ready and willing to hear them. I'll take notes and refresh my memory at the time that the evidence is sought to be admitted.
Okay, may I have a moment, please?
Sure.
The defense has a suggestion.
Sure.
Since we have gone through all of the photographs and labeled them, we can send that to the state, and they can in fact verify that what we have labeled the photograph is what that photograph represents, and we can put all of our objections in writing. That way, Your Honor, because they are relevancy, cumulative, probative value of a presidential nature, that way you can review them as before the trial or before the admission of that evidence, and then we can make our objections if they're not clear enough in the written plea.
I think that sounds like a good idea.
And Your Honor, we
For,
will,
excuse me, just for determination at the trial,
Correct. I think that's what you meant.
because you still need testimony. Is that what you're saying?
Yes. But you would have a heads up.
I think it would be helpful for me to be able to view these things beforehand, even though they're not entirely clear as to what's happening or what the purpose of a certain photo or video is being made for, but it familiarizes, I can familiarize myself so that when I look at it a second time, it's not, I don't have to probably study it as long.
All right, so you would like, just like you were given a copy of the videos, you would like a copy of the photographs?
If both sides are in agreement, I think that would be helpful for me to be able to rule at the time of trial and not have to take as much time viewing these things.
Okay, so we can agree, we'll give you the photographs that we agree upon, so
Do you agree that the state is going to seek to introduce?
Okay, that's fine. I thought that that's what we were doing. We spent 3 hours doing that before. We don't mind doing that. The only thing is that there may be other photos.
Sure.
There's thousands of photographs in this case. We have a feeling of what will be relevant, but there may be something that comes up
Sure.
that we didn't send. In other words, every photograph we have sent to defense.
I understand what you
We
mean.
have given them a list at their request of what we think we're going to introduce out of the thousands of photographs. That was the purpose of that meeting we gave it to. So we don't mind giving the court, if they want to, the photographs, so it won't be the first time you have seen it, but we don't want to be limited to the
No.
450 if there's something. Of course, we've shown to the defense
Sure.
before we move.
Things change, and
Right.
I'm not asking you to live or die by this list that you're giving. I mean, same thing with both sides. There might be something that you want to introduce that you didn't think you were going to, but I mean, a trial is fluid, and I understand that.
And I had this exact same conversation with Mr. Seth the other day.
Sure.
He said there may be additional photos.
Of course.
I totally get that. But I know that that decision will not be made 5 minutes before somebody testifies.
Sure.
So I asked, can you give us a heads up? And he said he could.
And that way I can be familiar with the bulk of the photos, and if there's other photos, by no means am I limiting either side. I mean, things happen, and you can only be as agreeable as you can.
And I don't mind meeting with them, and I thought the meeting that was, if they say, hey, look, this photograph shows the same thing, and I'd say, well, no, it doesn't, and I'll tell you why.
Okay.
I mean, I'm not saying I'm telling them to agree with us,
Sure.
but at least they'll understand why we're doing it, because to be honest with you, and I told Melissa, or Miss McNeil, that we have culled these photographs down. We even crop photographs, so private parts are not in the photographs.
Got it.
We try to be as careful and discreet as possible. And we don't mind, if they think it's cumulative, we'll say, well, here's the not that they have to give in.
I
but,
understand. So the state is saying, I think what they're saying is they have to explain to you why they believe a certain photograph that may, on its face, appear cumulative, why they believe it's not. They're not asking you to agree, but they're happy to give you a heads up as to why they believe something is relevant.
No, and that's great. That will be very helpful. That's in fact what I thought we were doing on Thursday. We just got through the videos. We came in with a list they'd sent us the night before.
Okay.
The photos weren't identified, so we
Okay.
didn't know what they were. We were not able to do that.
Okay?
Yes, and there may be some we agree with as well.
Okay?
So I'm wondering if I can propose something to the court and to the state.
Okay?
Mr. Savicki sent us a list last week about numbering all the photographs you guys were going to use. He amended that because it was duplicitous. We have gone through and next to each photograph identified what that photograph is. We can provide that list to the state. If you are in agreement that those photographs do represent the number, then we can tender that to the court, or we can reference those numbers in our motion along with our arguments and the photographs. And then that way we know as of what you believe you're going to be introducing today, we can get her to do that. And then if there's other photographs moving forward, we can deal with that as we move forward.
I don't really agree with that. I don't mind the judge seeing the 450 photographs. That'll help the court. But I don't, without taking testimony, there's no way to look at the relevance or the argument that it's cumulative. I don't mind discussing with you, look, we're going to disagree, because we always do. But, and I don't mean that disrespectfully.
I know you don't.
You
But
have
we
a
have
client,
agreed
you
on a
have, you
couple.
have a client to represent, and you do it well. I'm just saying that there's going to be differences, and I mean this sincerely. I don't think anybody can make a decision on a photograph or a description without putting it in context with other things, and it would be unfair for the court, in my opinion, to do that. But I don't mind meeting with you at any time and say, look, this is the reason why. And although this figure shows 3 wounds, this is why this other picture is just as relevant, and it's not cheap.
If I can add an example, there's one.
I like examples.
There's one photograph that's mentioned in their motion about a gloved hand inserted into a wound. Well, what the picture actually shows to the state is the doctor is showing, it's an autopsy picture, is actually showing the fragment coming out of the body. And so he's pressing against it and there's a fragment. We don't want to waste, our time is very valuable. We don't really have all the time that this causes us to have, of trying to explain every single picture. This will come up in that individual medical examiner's testimony as we show the pictures, or the defense will know which ones are going with that particular victim, and they can make their objection, and it's done in 2 seconds, as opposed to going through a hearing today, going through their lists. We know what we're doing as prosecutors. They know what they're doing as defense attorneys. During the course of the trial, this will get sorted out, and it gets sorted quickly. Some people may want things done a different way, but it takes more time this way.
defense is going to do is we are going to file a written response
Okay,
with our objections. We will identify the photographs as the state has provided us with the numbers.
Okay.
In that pleading, we will describe the photograph so that when that photograph is moved into evidence, you will have a heads up.
okay,
And we will file that for all of our objections collectively, and then we may be able to agree with other issues.
okay.
I think that would give the court the ability to have a heads up for the information that's coming in and to be able to rule on the issue instead of having to take time and, put it all in context.
Okay,
And we have no objection to the court of viewing the 460 photographs that you shared with us.
okay. Okay, so did either side have any luck on scheduling the experts?
I have reached out to our main Daubert witness, as Your Honor requested, and he is in the process of verifying with his assistant whether or not the week of the 15th is available to him. He's supposed to testify in a different case on that Monday, which I believe is August 15th, but he said even if he does have to testify that day, he could be here later that same week, but I'm waiting to hear back from him. There's been an exchange of emails, and all I can tell you is that we're working towards that week as best we can, and I'll let you know and the state know as soon as I get any additional information, if that's all right.
Do you think you'll have that by tomorrow?
I hope so. I think we got 4 or 5 emails from them today, so they're being very responsive and they were trying to reach out to the legal team in the other case that the doctor's supposed to testify in to find out whether or not that really was a date certain for his testimony so that he could come here in the event that they weren't positive about his testifying date. So I expect to know today, and like I said, we'll let everybody know as soon as I do.
And state, are your witnesses available that week?
They're available that week and the following week, so however, if Dr. Adler testifies the 16th or 17th, we'll be ready on the 18th.
And what about your other witness?
She is currently prepared to be here next Wednesday. Is that the 13th? If that still suits Your Honor.
Oh, that's right. We threw out so many different scenarios that I forgot. So you were going to call your first witness on Wednesday of next week, and then your second witness, hopefully the 15th, and then the state would put on their witnesses that same week.
Or the subsequent week, the week of August 15th and or the week of August 22nd, I believe.
Judge, and I just remind the court, August 19th, we're not in session.
Right, and we're supposed to be off on the 18th, but we can open that date up. I mean, I'd like to get this done on, if we could finish it on like the 15th, 16th, and 17th, that would be ideal.
I doubt there'll be enough time for all the state witnesses.
3 days?
No.
15, 16, 17, 18.
I think if Dr. Adler testifies on the 16th, it will go a full day, possibly spilling to the 17th. The state could start on the 17th with a witnesses on the 18th, and then finish up the following week.
That defeats the purpose. I want to take 1 week break to finish this hearing. That would be like a 2-week. So the defense is going to find out if their witnesses can come on August 15th. If their second witness testifies on August 15th, then state your witnesses could be on the 16th, 17th, and 18th.
I just don't think it's enough time, Judge. I think we're going to still need a few days to pick the following week. And with the 19th off, unless the court wants to start the 21st, and then yes,
Can we finish with the state's testimony on the 19th, defense?
I'm sorry, I missed that.
Can we finish the state's testimony on the 19th? We're supposed to be off that day at the defense request, and I'm not sure if we can go forward on the 19th.
Yes, ma'am, that's okay.
Okay, so if the defense second expert testifies on the 15th, then the state has from the 16th to the 19th to finish up.
I'm waiting to just hear back from one expert, but as far as I can say right now, I'll move mountains to make it happen.
Because with Dr. Brandon, he didn't actually need a whole day. If we would have started just a bit earlier, not taken as long during lunch, and gone till 5:30, we could have probably gotten 1.5 witnesses on.
It's different, apples and oranges, I think.
Well, only because you all said, just like Dr. Brandon, we need a full day per expert. That's the only reason I was saying that he wasn't really a full day, it was more like 3/4 of a day. I understand it's a different subject matter, but
I'm happy to try, Judge, that's all I can.
All right,
I just don't know
15.
how long cross-exam's gonna be, I know how long my direct's gonna be, so.
all right, the 15th through the 19th. And then next week on the 13th, the 4th DCA is going to be in here on the Tuesday morning of the 12th. And there is one additional motion that, motion to have a witness, order the witness to answer questions.
Yes, Your Honor, our office, I wasn't in direct contact, but our office contacted, I believe her name is Miss Amina Willard, I believe is the name. Am I pronouncing it correctly? You don't remember? Okay. I think that's her name, who represents both witnesses. She indicated that she is not available this Friday, and I believe she also indicated she begins a 5-day jury trial on July 11th.
I think the best course is to subpoena those witnesses to be in court on a certain day.
They're in Virginia, Your Honor,
Because I don't really care what trial she has, it's not as big as this one.
if I could, I will direct her to your JA, and your JA can contact her and advise her accordingly, if that's okay with you.
Isn't there, I thought there's a way to subpoena an out-of-state witness. Didn't you do it through,
I don't think I could go under an interstate compact because they're not a material witness for me. It's a deposition, so I'm not.
are you calling the witnesses or the defense?
It's a defense witness, 2 defense witnesses.
So if and when they come, can we not just handle it right before they testify?
Well, it's to continue the deposition. This is for deposition questions.
So there were a number of questions that were not answered,
Yes.
not just 1 or 2. Okay, well, then defense, I'm gonna say what I normally would be saying to the state. If you wanna call these witnesses at trial, you're gonna have to get them to cooperate beforehand and at least make themselves available with their lawyer so that I can make the determination of whether or not they have to answer the questions. If it was a state witness, I would tell the state the same thing.
Well, Judge, I can't communicate with those individuals because they're represented by counsel, or else we would have been involved in this. Mr. Marcus reached out to me initially, and I said they have counsel, so.
I think you can call their counsel and let them know the judge is not gonna let these people testify if they don't make themselves available for this pretrial hearing.
And what's the date? that they're proposing?
Well, she said she's not available tomorrow and she has a 1-week trial, so, we can do it any day. It's gonna take, what, 10 minutes? It's gonna be a Zoom hearing or a telephone hearing?
She represented that she wants to be in person. So I said that the court had said Zoom would be fine, but I think I need to get out of being in the middle and give it to the court's JA to speak to her directly, at least by email, or the parties all together, including the defense.
So the witnesses and the lawyer wanna be in person?
I don't want to speak for them.
me a favor, Judge?
Sure.
If you want to give me whatever dates, tentative dates for a hearing, I will call the attorney and I will say, if you don't appear in court, then the judge is going to strike my witnesses.
Okay.
Now, I don't know what, if she's in a jury trial next week, what that court's position is going to be if she's not available, and I don't know if the court.
I'm not gonna set it next week, I'll do it on the 18th. I know we're having a Daubert hearing, but we'll do it first thing in the morning. It shouldn't take more than 30 minutes, right?
It should be quick hearing, I think.
The
So,
18th of
August.
Oh,
I mean,
okay.
I just kind of threw that day out. August 18th at 8:30.
August, not July.
No, is that all right?
Judge, if I may, the 18th, for this, I may have 2 witnesses on the 18th, because of, so I just want to bring that up so that we don't run out of time.
I don't want to take the person, I don't want to schedule it for a day where we're supposed to be in trial. So,
Just-
yes?
I just emailed the Jay that my appointment on the 21st was canceled due to the doctor's unavailability. We would have that afternoon, and you told the jurors we're off, so if they're available then, we could do that. I just rescheduled it for the following week, and we're not in trial anymore.
So can I use those 2 possible dates to tell the lawyer?
Oh, I see what you're saying. That's perfect. We'll do it July 21st at 1:30.
And in the event that that does not work, the alternative is August 18th? Is that what was the August date you said, Judge? August 18th.
Oh, I'm sorry, let me just look for a second.
And you think it's Mr. Marcus 18th? I don't, nothing is ever.
I don't think anything would be short with them.
18th is bad because we have those witnesses for the over.
We can come.
I'm talking about July 21st at 1:30.
That's perfect.
Because she was not available, you said she wasn't available on the 8th and she wasn't available the week of the 11th.
I believe that's what the email said.
Okay, so July 21st at 1:30 for the afternoon.
And in the event, for some reason, she has a conflict which she cannot get out of, can we also set it for August 18th? The defense can be here at 7 o'clock in the morning if we need to be to get this done. Or we can stay
Right,
late.
August 18th at 7:30 a.m.
And is it the court's position if she fails to appear or cannot make time for the hearing that you're gonna strike those 2 witnesses?
Well, if the state doesn't get to depose them based upon, I don't know what privilege they're asserting, but whatever it is, and they have a lawyer who's supporting that position and not allowing them to speak to the state, then yes.
I just want to make sure that the representation that I'm making to this attorney is accurate.
Yes, I'm gonna
Okay.
strike the witnesses and they're not gonna testify, and,
Judge, I'm sorry to be a pain with this. Is there any other week or day that week we can use instead? That
Okay,
would be the only day we'll.
everybody needs to understand something, okay? There are 5 lawyers for each side, and now we have another lawyer in another state and 2 other witnesses, and we have all of these people. Everybody needs to, and now we have all these experts that we have to coordinate. This is getting too much. So, no, we're gonna do it July 21st at 1:30, and if she can't be here on that day, she's gonna have to be here August 18th at 7:30. I don't know anyone who's gonna choose August 18th at 7:30, but if that's her last choice, because she also had the option of the 8th and she declined, and she had the week of the 11th and she declined. So if she's that busy, then maybe she needs to refer these witnesses to a different lawyer. All right. So basically, there's nothing that you all are working on your own tomorrow and Monday. And Tuesday, and I won't see you back here again until Wednesday. Is that correct?
Yes.
So there are Wednesday the,
13th.
I'm sorry, what do we have scheduled?
On Wednesday, July 13th, we're beginning the Daubert hearing,
Okay.
and
Yes,
Mr.
yes.
Secor is calling a witness that's going to take
That's fine.
the entire day.
So we do have other motions that we have filed, if you want to set them for Tuesday, and we can deal with all of them that day. There are no witnesses that we need to call.
Okay, I'm happy to set aside Tuesday afternoon, the 12th, for the entire afternoon. But I would like to leave it up to you to tell me what.
I can do
Can
that
you
right
just
now.
do it? Okay, go ahead.
Defense has previously filed DMIL number 3. And you signed an order deferring ruling on some things, so we need to get that dealt with. Your order, just for a point of reference, Your Honor, was signed sometime in December of 2021.
Okay.
That's ML1, MIL3.
That I deferred ruling on.
You ruled on some of them, the defense and the state agreed on the majority, and then there were a couple things that you deferred on. I think it's, if you read your order, it's in there.
I'll go back and look it over.
We also have,
But
There's
was
no
it
hearing on
deferred
the
until the time of trial? I don't remember.
you'll have to read,
No, give me just 1 second. Let me go grab my.
I have a copy of it.
May I approach? Sure.
So what I'm giving the court is the order on defendant's motion in need to exclude unrelated firearms, ammunition, and firearm-related material, DMIL3, and there's no notations on it. By way of example, Judge, in MILQ, which was a packing list, listing the firing pin and the ammunition recovered from the dresser, the court had ruled that it was admissible only if the state could show that the firing pin on the list is the same as the one used in the crime. I don't know if they're able to do that, so you deferred ruling on that. And then R, which is the packing slip from Cabela recovered from the dresser, and you deferred.
I don't see R. R? Am I missing something? Is R on the same motion, the same order?
Can I see the order, please?
Sure.
Oh, you know what?
It's not in the order, Your Honor, it's in the defendant's motion.
And the transcript and your order are in conflict. So if you want me to give you a copy of the transcript, so
But
you
I
can.
may have said during the hearing, I'm gonna defer until I think
Yes.
about this, and then I wrote an order subsequent, so that would be my order. Do you know what I'm saying?
Yes. It's not in your order,
Okay.
but I think it's in the
R
transcript.
is not in, I said I was gonna defer on R, and I didn't address it.
And then,
Okay, so, excuse me just 1 second. R is mentioned in the second paragraph on page 1. A ruling regarding the item marked R is deferred pending submission of additional evidence by the state. So I assume that would have to be at the time of trial. Do you see the paragraph, the sentence I'm talking about?
you have my only copy, but I assume that that's fine.
Let me just grab my copy. I'll be right back. Give me 2 minutes.
that woman's contact information, please? Just in an email or text it to me or whatever.
Come to order, remain seated.
I don't know if she's finished it. She was pulling it.
Do that for July 12th. Are you making fun of me?
Okay, Ms. McNeil, I thought this was mine to keep, so I circled Q.
Okay, I don't mind if the state doesn't
but
mind.
We can print another copy.
Well, we were
It's
gonna
just
talk
hard
about.
to get through that file. It's so voluminous that it'll take me a minute to find it.
Do you have a copy of this now?
Yes,
Do you, she did an notation on it, here?
No.
I just circled Q.
No.
So the order on DMIL 3 was entered 12/6/21, if that makes it easier for you all to find it.
Rhonda, we can announce to the defense that the state is not going to use Q, the firing pin.
Okay.
In evidence. We do reserve that if for some reason that I can't anticipate it became relevant, then we'll readdress it as to why it has become relevant.
Okay?
Could you send me an email saying that?
It's on the record.
We can do a short order. Okay, so that
I
takes,
can write up the short order.
that takes care of DMIL 3.
GG, on that same motion, Judge, the court deferred until there was a ruling on SF 109. The court recalls that was the initial swastika motion. This is the Mossberg 12 gauge shotgun that was found at the McCutcheon's Everglades property. 2 weeks ago, I also mentioned to the state that this was an issue that needed to be resolved before we moved into general voir dire.
The admissibility of that, if the state were to seek it, is because it has a swastika on it, that other witnesses would testify that the defendant kept at this property in the Everglades. It's not our intention at this point to use it, unless it's rebuttal evidence. What we've addressed in our motion yesterday was that we were going to use swastika evidence in rebuttal. And that's all I can say at this point, Your Honor.
Well, then that issue kind of resolves itself, right? For now. GG?
Yes.
The only thing I'd just like to add that this was one of the motions that we asked that the court hear before we moved into general voir dire, so that we could get a ruling on whether or not the swastika information was going to be admissible, so that we could conduct our jury selection accordingly. And since this was not ruled on along with SF 109, the defense did not voir dire on the prejudicial nature of the swastikas.
Since the defense put that on the record, Your Honor, I just would like to respond that I advised in open court before voir dire had finished that we intended to introduce that information, swastika and other hate information. The defense chose to not ask to continue voir dire, but voir dire had not finished. We had not selected a jury when they were advised of that.
And we objected to going forward, Your Honor, and the jury was not present when Mr. Marcus made that statement, and Mrs. Curtis made a record that we appreciate that, but we don't want to move forward, and we moved forward, and we indicated previously the prejudice to the defense.
Okay, I'm well aware of both parties' positions. I've also reviewed the transcripts of when this issue was brought up, and we're just gonna move on.
That's fine. So I think everything has been dealt with for that MIL 3, unless the court sees something that I missed.
I don't.
Okay.
Okay, what else?
You're gonna just rule on MIL 11, which is the redactions from the defendant's statement, right?
Yes, I have, as long as both sides are okay with that, I have been provided with the transcript as well as the actual videotape and the parts that the parties are not in agreement on. Do you want to?
Judge, I did want to just supplement the record with why we're disagreeing and what the relevancy would be.
So hold on just a second. Can we do that now?
I'm going through it now.
All right, I just want to I need to just shuffle some paperwork, okay? Give me just a second, please. Okay, so for the record, we're talking about DMIL 11. And do you have the defense motion in front of you?
I do, Your Honor. I also wanted to, just in the interest of time, DMIL 13 was also filed. I don't know if the court had an opportunity to look at that. It's a motion limited to exclude law enforcement opinion testimony.
So, Judge,
If I could just finish, please. There's nothing, actually, there's no lines or page numbers referenced in there, so I'm not sure exactly what the defense is seeking to exclude. If it is encompassed in MIL already, then we can probably address them both. If it's separate and apart from what's already listed at MIL 11, then I guess we'll have to have a separate hearing.
Judge, and Your Honor has not received the exhibit because it was too big, and I am bringing it to you now.
What is
I
the
may have
exhibit?
To MIL 13.
What is it though?
It's for law enforcement opinion and motion limiting.
I know, but what's on the exhibit?
Oh, I'm sorry, it's Detective Cursio's complete reports, which is 896 pages, and his deposition transcripts. So it is not, it encompasses partly DMIL 11, which is Mr. Cruz's statement, and opinions made by Detective Curcio during that statement, but it also has other documents where he places opinions.
Wait, hold on just a second. I mean, but just to narrow down the issue, you're talking about when he says things about whether or not the defendant understands what's going on and whether or not he hears voices, those opinions? Or is there something else?
Amongst others, yes, Judge, there's other opinion testimony. That
Okay, so we can't hear DMIL 11 simultaneously with 13.
there are other documents in 13 that are not included in 11.
Can you just summarize what those things are? Because maybe the state doesn't anticipate eliciting those things from the detective.
I mean, it's a lot, and she hasn't had an opportunity to look at it. I mean, we're talking about 896 pages.
Yeah, but he doesn't give 896 pages of opinions. He's probably, what does he say? He says something about the defendant's mental state. I'm sure that's one main group you're talking about.
Right.
And what is the other, just Reader's Digest version, because they may not want to elicit.
Judge, we're not gonna elicit opinions from Detective Curcio as to guilt or innocence for a variety of reasons. I just don't understand why the statement or his report is in there and his deposition. The only thing that would be relevant would be what was in the confession.
I mean, I think the law is well settled. It would be inappropriate for the state to elicit a guilt versus innocent opinion from the detective, or really.
Well, that's not the issue. The issue is, Your Honor, as you brought up, commentary and opinions on as to Mr. Cruz's mental state, right? And then the other would be Mr. Cruz's veracity. He shouldn't be able to testify to that, and that is included. The case law is included in my pleading regarding that. But throughout the 896 report, there's multiple times that he makes various opinions. I've highlighted my copy. I'd be happy to share a specific page and numbers to Chiapponi, but I do not have that collected right now for her to review.
I think it's pretty clear what you can and
I
can't
was
ask
gonna say,
the
Judge,
detective.
I know what the law is. I'm not gonna be eliciting opinions without establishing a foundation from any witness. So, and as far as mental health is concerned, the detective can certainly talk about in the confession what he was observing. If somebody was having a psychotic episode or not having one, I mean, he's simultaneously watching and talking to him at the same time. The case law is pretty clear. I mean, that can be discussed during the interview. I mean, it's an interrogation.
Judge, Detective Curcio is not qualified as a mental health expert.
I wouldn't be asking him to diagnose him, but if he's vigorously shaking, I think he could testify to that.
Of course, to his physical observations is what they're saying. What they physically observed him doing. I mean, why could he not testify to that? That's not an opinion. That's a statement of fact based on someone's direct observation of the person.
So if you look throughout the statement, there's not a place there, and maybe I'm misspeaking, but there's not a place in there where I say where he's shaking or nodding his head, or that Detective Curcio can't testify to that, or that shouldn't be allowed in. I'm saying things like when he's saying, I don't believe you are mentally deficient, right? I think you understand everything I'm saying.
All right, let's do this. Let's go through DMIO 11 first, and I think that might resolve some of the issues. So, DMIL 11, paragraph 3 indicates that the state and defense have agreed to the following redactions, and then it lists paragraphs A through F. Then, paragraph 4, it says the defense is requesting to redact the following statements of Mr. Cruz to Detective Curcio, in which the state is not in agreement. So basically, paragraphs A through P under number 4 are in contention as far as whether or not they're going to be redacted. The defense has outlined its argument in their written motion as to why these matters they believe should be ordered redacted from the statement, and then state you want it to be heard as far as your position goes.
As quickly as we can, Judge, yes.
Sure, so let's just start with A, page 11. Okay, so defense, I have, my initial question is you have something highlighted on page 2 and there's no mention of page 2 in your motion.
There is, that is green, then we agreed to take that out. And it should be in my motion. I think it's letter A.
Okay,
Do you see it? You have the amended motion?
I'm gonna, if you all are in agreement, I'm not even gonna bother with it because I don't need to, okay? So we're gonna start with page 11. Lines 13 through 15, where Detective Curcia says, okay, well, I think you can remember, but we'll get into that as we get into...
Judge, I don't see what the objection is. I mean, if you read it in context, the defendant is claiming he doesn't remember his number, and the Detective Curcio can, provoke a relevant response, which is, you don't know your own number. I don't see what the prejudice is about letting that in. And then he does give the number. And just so for the record, the case law I'm going to be relying on is Darrell v. State at 58 7 3rd 357, McWaters v. State 36 7 613, Cruz v. Cruz C-R-U-S-E v. State at 588 7 2nd 983.
I'm sorry, Nicole, could you please give us an idea?
Sure. Did you get the spelling of Cruz?
It's C-R.
U-S-E v. State 588 7 2nd 983. McWaters 36 7 3rd 613. Darrell v. State 58 7 3rd 356. And Shepherd v. State 151 7 3rd 1154.
I'm sorry.
151 7 3rd 1154.
1154. Thank you.
Right.
Judge, the only thing that I could say is I need to read these cases. I mean, I haven't had an opportunity to read them.
Okay, but, guys, this isn't rocket science. I can read through this transcript and listen to the statement and determine what I think is admissible and what isn't. You all want to have an argument on every single 2 lines?
And to be honest, Judge, that's what you said yesterday afternoon. I thought that's what was going to be done.
But the state hasn't had time to file a response, so they just wanted to respond orally.
I understand, but if they're going to be relying on case law that I haven't reviewed, that
Judge, I can make a general argument as to all of the objections or everything that we're not agreeing on.
Okay.
If the court wants to then apply that and going through it, on your own separately, and then if the defense wants to supplement with any filing, that's.
I just think most of this is pretty straightforward and it's not.
I agree. It's the same, over and over again. I understand the case law. Detective Curcio cannot elicit opinions about guilt or, if there's constant repetitive questioning and there's no answer, but to elicit questions that provoke a relevant response, for example, like we just went through with, trying to get him to admit that he knows his own phone number. He is permitted to talk about his observations in terms of even whatever, I want to say mental health, but whatever mental condition is going on in front of him, he can make observations as to that. A lot of this content, he refers to the voices. He refers to things that he was doing prior to the incident. That goes to aggravating circumstances. The voices are going to be part of mitigating circumstances, so it's relevant in that context. Nothing that the defense is looking to admit is prejudicial. So I would say the probative value outweighs any prejudicial effect in the instances where we're not agreeing.
But it's hearsay, though. I don't know that you can say it's probative.
Well, you'd have to go to a specific.
Well, anything the detective says is hearsay.
Well, what not if he's on the stand? I mean, he can testify to it on the stand.
Okay, but I thought we're talking about the statement right now.
Well, but we're talking about playing the statement, so his words would come in.
But they come in to show what the defendant's response was. The detective's words are actually hearsay, and I understand that most of the detective's interview is admissible because it shows the context in which the defendant's statements are made, but I don't think you can say what he said in the interview is probative when it's really hearsay, all of it.
But it's not coming in for the truth of the matter asserted. It's coming in to put the entire interview into context.
Right. I agree with you as far as that is concerned, not necessarily on this specific subject, but okay, go ahead.
I mean, that's more or less what I would be repeating over and over again with each one of these lines that we're disagreeing on is that, you know, if he's asking him a question that is provoking a relevant response or provoking a reaction from him, he can confront him with evidence. You know, saying that he's not being truthful or not being honest with him is not inadmissible because he's there, he's observing him, he has gathered some information, and so he knows what is, you know, a little bit of what the defendant will or will not know at that point, especially his number. And if he's not making sense, then it would be remiss of Detective Pursuit not to continue pressing him to ask him to give relevant answers. So, I mean, more or less, that is what the state's argument would be throughout all of these pages.
Judge, and if I could just add a couple things.
Sure.
First of all, what Detective Percio says is not relevant, right? We're talking about the defendant's statement, that's what's relevant, the responses, right? And I believe you touched upon that. Also, our concern is not what the state's going to elicit. Our concern is that Detective Percio continuously has a tendency to comment on issues for which he is not qualified. Mental health, medical, I wouldn't say diagnoses, but medical type information. And we are asking to limit this type of commentary and for him to be responsive while he's on the stand. That has to do with 13, so I'm sorry to mix them a little bit. But that is the main concern. The law that I'm relying on is in my pleading. I stand by that pleading. It does talk about the veracity, not just the guilt and innocence, comments on the guilt and innocence of the defendant. Further, I also place in my motion that I understand that law enforcement is allowed to invoke relevant responses, right? I understand the case law is there. I address that in my motion. So that's
Okay, so I can rule on DMIL 11 and 13 without further hearing.
Correct, Judge.
yeah, I would agree with that. Judge.
All right.
I stand by the pleading on that. You want the folders, what I'm asking.
Okay, so just for the record, the defense has given me DMIL, well, let me make it perfectly clear. The defense has given me DMIL 11, which appears to be a zip drive.
Yes.
Is this an extra copy?
That is your copy that you requested of the video.
Right, but when I
interview.
say extra, this is not evidence.
Correct.
I can return it to whomever when I'm finished, but it's not the actual item that you're admitting into evidence.
Correct. That was to assist your honor.
No, I appreciate it, I just want to make sure. So do you have another copy of DMIL 11 that you want to move into evidence as far as consideration of that particular pleading goes for purposes of appeal, for the record.
I will let you know. in just a moment.
And state, do you have any objection?
No, Judge, do you want my copy of the case law?
Sure. So,
I'm gonna show you.
and they can be the same. In other words, I can just check out like a library book, the evidence, and I will return it.
That was the purpose of me giving it to you, was just to assist you, not to enter into evidence.
Okay, but
And if I feel like I need to do that, maybe I can amend it and do it later. Supplement the record later. with
all it is,
copies.
this is just a defendant's video statement.
Correct.
Got it, okay. Then, DMIL 13, you gave me a DVD or a CD with,
The exhibits, because they were too large to e-file.
which are listed in your motion.
Correct.
And you also want to admit a copy of DMIL 13 exhibits into evidence for purposes of appeal.
Yes.
State, do you have any objection?
No, Judge.
To the hearing. I can cut them out. And it goes with the motion. The motion will be filed.
Judge, did Ms. Ashman, have you highlighted what is in the reports and the deposition that is relevant?
It's not included in here, but that is something, to me, it's work product. I was not going to share that, but I would be happy to share that with you and make a chart of the things that I found. If you would
I
like.
think that's relevant to your argument. I mean,
Okay.
otherwise there's thousands of pages in there. I have nothing to do
Well,
with it.
896.
Give or take.
That's fine, I have no problem doing that. Would Your Honor like a copy of that too?
You mean to narrow down exactly what you feel is not admissible,
Yes.
as opposed to giving me 900 pages of,
Well, that's also the deposition transcripts. And that I don't have narrowed down.
We would object to the exhibit as being so vague. It's, I'm sure the deposition is hundreds of pages as well, and then his report is almost 900 pages. And the motion is very general as to law enforcement opinions are inadmissible. How could the court possibly know what the defense is talking about?
Judge, I can fix this problem.
okay,
I will take these back.
okay?
And
Wait.
we give your,
You're not taking
not
MIL 11.
correct.
You're gonna take this,
I will provide the court with, and the state, and the clerk with another dip, just because the documents are so long,
okay?
with my highlighted.
What you
file.
believe is the subject at issue.
Correct. Will that make it better for you? They're highlighted, so you'll be able to go through it. You don't have to read every word. And guess
And
what?
I haven't seen it yet, but I'm thinking you all are gonna look at it and say, well, we're not going to elicit these things anyway. I don't know what they are, but,
I mean, the motion just might as well say, follow the rules of evidence, and we will.
all right.
So just so it's clear, Judge, our concern is not with the state eliciting improper testimony, okay? We understand that they know what is permissible and what is not permissible. Our issue is with Detective Curcio. When he gets on the stand, he tends to ad-lib and add things that are not admissible. We're using his report as an example of that. He literally cuts and pastes from Wikipedia what he thinks Mr. Cruz's diagnosis is. He makes interpretations as to what is happening on certain phone calls.
Okay, but
Right, so we're trying to limit what Detective Curcio will be saying when he testifies, because he has a tendency to do that. So we're just gonna, the statement, or his 900 and something pages, is to give the court an idea of his tendency to go outside of his lane. Now, we don't anticipate that the state is going to be doing that improperly. He has a tendency to do that. So we just want a ruling or an order from the court telling Detective Curcio, you're not a psychologist, you don't need, something like that. So
Judge,
that
this
he,
is- I'm sorry.
so that he doesn't have a tendency to ramble on the way that he does.
I think the state's on notice now. What happened to the old-fashioned way of just me telling the state, pre-try your witnesses and make sure they know what they can and cannot testify to.
And
I
there's
think
also
that they do that.
objections that defense can make if a witness does that. I mean, that's what objections are for, hearsay, whatever.
All right, you're on notice, state that the defense is of the opinion that Detective Curcio talks about things that he is not qualified to talk about.
Detective Percy is a very seasoned detective, however, I would instruct him to not make any opinions he is not qualified to make.
Or his commentary that he has a tendency to make, as demonstrated by the motions to suppress where he testified.
I think he knows the difference between what you can put in a report and what you can say on the witness stand.
I would hope so.
All right, let's not do this back and forth, especially when there's multiple lawyers. It's like my dinner table.
So just to be clear, the court would like my highlighted copies as well
Listen,
as the state.
I think that I can't rule on every single issue that may possibly come up. I understand your concern, but I think you putting the state on notice and so that they have the opportunity to pre-try their witness in the way that they want to and make sure, I'm gonna expect from both sides that you all pre-try your witnesses so that they don't have diarrhea of the mouth or say something that's inappropriate on the stand. And so if you want, I'll issue, this is a standing order. I expect at this level, both sides to pre-try all of their witnesses and to go over sensitive areas that the witness may or may not know they're allowed to talk about. And I'm also going to be paying very close attention so that if I see something that's coming, I'll be either interrupting or waiting for an objection. In other words, if I can see where a witness is going and it's in a place that's not going to be good, I might say, can we have a quick sidebar or something to that effect? I don't think it's going to happen in this case because the lawyers on both sides are very experienced, but
Thank you, Your Honor.
we should all be on notice about that because sometimes even an experienced witness just, you know.
We just want to try to prevent a mistrial
I absolutely agree.
on both sides, so.
Absolutely.
If we have a court order, that helps.
Do you want me to put it in an order that I expect both sides to pre-try their witnesses and review in advance the rules of evidence?
When you make your ruling on MIL 13, that language could be included.
Well, that is my ruling.
Okay. Could we have a written order next week?
Sure.
Thank you.
Well, I'm sorry, and I think that might be entertaining to the individuals in this courtroom, but when something like that happens, instead of us combing the transcript, then we have a document that we can.
No, I understand. I understand, Ms. McNeil, but you're a very prepared person, and unfortunately, I can't anticipate everything that might happen, but I appreciate you guiding me in that direction of I think pretrial orders are definitely the way to go, if you can anticipate everything, but some of it, we're just gonna have to.
And I agree,
Wait
but
and
we have examples with Detective Curcio, and you know what, I don't wanna try this case again, I'm sure the state doesn't wanna try this case again, so if we can try and do things to prevent a potential mistrial.
Absolutely.
So we have a couple other motions that will probably be filed by the end of the day, they're quick, if we wanna put it on, what half day did you give us next week?
Tuesday, July 12th at 1:30. And by the way, while we're here, let me say this, the 4th DCA, I guess, comes with the U.S. Marshal Service. I didn't know that. And so they're gonna be carefully combing through this courtroom before they start on Tuesday, so everything has to be removed, all your personal stuff, please. If there's anything that's a real pain to move, I have room in my conference room. If there's something that you all need to store there, that's fine. I don't,
Is the printer okay?
I assume.
Can we store the table again back in?
Absolutely, absolutely.
Thank you.
Judge, we also provided the state with the preliminary jury instructions with some proposed changes. I'm just gonna let the court know that, maybe if they don't agree, then we can also deal with that on Tuesday.
Are you talking about preliminary jury instructions as in the rough draft of the final jury instructions? Are you actually talking about 2.1, et cetera? Like
7.10.
7.10?
No, that's fine. So she knows
I may have already read it. Let me just see.
So it's 7.10, this is what you would be reading to the jury when they come in initially. And then we've been working with Mr. Marcus about other changes to the instructions as we move along. But that's one that I think needs to be heard.
Okay, just give me just 1 second, please, so I can pull up.
Your Honor, regarding 7.10, if we could discuss that on Tuesday.
Sure.
Yeah, that's what
Oh, I see, because there was no guilt phase, it's gonna have to be modified. All right, so, yes, we can go through that, and I will look through it ahead of time also. So I am inclined, even though I've read it to them previously, but to reread, I think it's 2.1, which just talks about how they cannot discuss the case even with your closest friends and family members. People may be interested, but you have to tell them kindly to go away, and I'm paraphrasing, obviously. But I think that 2.1 or a modified version of 2.1 and a bridged version of 2.1, I will continue to read throughout the course of the trial.
The defense has no objection to that.
I think it's always just a good idea to keep reminding them.
And then the defense would also request that when the jury appears every morning, you ask them if they have been exposed to any media, anything, even accidentally, that they need to bring to the court's attention. Because somebody may have talked to them, not knowing they were a juror. And the defense would like that inquiry. If you want, I can give the court a proposed inquiry, and then you can work off of that, or you can deny my request. Either way, that's something we would like.
I'm not saying that it's right or wrong, but I've never done that before. Is that something that's commonly done in this type of a case?
Well, it's a high-profile case, so even if somebody is, avoiding the news or avoiding, what we would commonly see, they could be on Instagram and there could be something, or they're at a restaurant and somebody's talking about it, or it comes on the TV. So I think that it would be prudent to make that inquiry every morning. So if a juror does, then we can just do that then, instead of after the fact, 2 years later, when they're interviewed, oh yeah, I knew about this, I saw that.
It's not commonly done, Your Honor.
All right, why don't you put together what you proposed, show it to the state, and I'll hear argument on it on Tuesday as well.
Okay. No problem.
Is it me or do the lights in this courtroom, some of them go off? Oh, because all of a sudden it'll look like the storm's coming, because the back section gets so dark. That's weird. I don't like that. Right behind you all, the lights go off, I guess if there's no movement. So it appears from my vantage point that like there's a bad storm coming and it's getting dark, but it's not. It's because the lights are like the kind at Publix where they don't go on until you walk down the aisle.
It's Florida again.
Ah, there we go. It's kind of ominous. I don't like it. Okay, is there anything else for today? And also, as far as Mr. Wheeler, this is your zip drive with those videos. So I will put it, what I did was I took my personal judge stationery and I put it in that envelope, and I'll put it in my conference room, and I'll give it back to you when we're finished with the issue. Is that okay?
That's fine.
State? Okay, and then I don't know who's providing the photographs, but if you're gonna put them on this type of a format, I'll do the same thing. I'll keep it secure, and I'll just return it to you when we're finished.
Okay.
Okay? Yes, we're recessed, thank you.
Judge, we're printing the cases because I have written on mine, so I'm sending you a clean copy.
Okay, thank you.
So in recess until Tuesday, 1:30.
Yes, just to be clear, we're in recess until Tuesday at 1:30.
Quiet, please.
Whatever you, I don't know how, until it, just be prepared that on Tuesday morning, there's gonna be lawyers from both sides sitting at the tables, and make sure they have some room, okay? In other words, when lawyers leave notebooks and things laying around, and other lawyers come in, they don't wanna sit down and feel like they're violating your space, you know what I'm saying? So just take all of your work product with you, please. Yes, or you can, I mean, you can get it tomorrow if you have access. They're coming on Tuesday afternoon, but because we're not gonna be in session, your access to this courtroom might not work. No, the fourth DCA is in here on Tuesday morning. And from my understanding, I don't know why they have federal law enforcement, but they do, and those people take their job very seriously. They're gonna sweep the courtroom and go through everything.
They're coming in the morning, we're coming in the afternoon.
Correct.
Okay, I have.
No, but so the courtroom, anything you don't want bothered or touched or, you know, them examining for whatever they examine
Right,
for.
no, I understand, I read your calendar, and I thought it was the other way around. No, I think I just read it wrong, and I thought it was.
Okay. Sure. I mean, I don't think they would mess with that, but I don't know. I only see my.
So we gotta take our stuff too then. Gotta take my
Those
box.
are-
Nobody's gonna see
But
it.
I wonder why the state courts get a federal law.
I'll be here.
You think they would have FDLE or something?
I don't know for how long.
Then I go to my
But why,
box.
no, why would the fourth state court of appeals have federal law enforcement protection? That's kind of,
You gotta take
So-
up your.
they're nothing compared to our guys here.
We're gonna,
Right, Gabe?
You're right, Your Honor.
Judge, we're gonna move this. This is being moved, and those things gonna be moved.
I'll clean up, don't worry.
No, you don't have to clean up.
No, I will, because I have crap everywhere.
Yeah, what we were gonna do is put it on the other side, that corner. Okay?
Yes, sure. You know, yesterday the staple bit me, and I was using that beautiful new book that Mr. Saxon, you know, they like, books like that, they like smell good, I don't know. And I had it asked for a Band-Aid, so I'm like, I'm not gonna leave them. It was just like a little